We are geared in this video to discuss sale of good, and this will be the format for sale of good. We are going to discuss section per section, those that we feel are very important, like section 12, section 14, section 17, section 15, section 22, passing of property 23, section 26. Of course, we have discussed section 29, 32 already discussed under Nemodat. And then we shall discuss 34, 35, the delivery, 36, 37. And then we shall move to section 50, unpaid seller, right of stoppage in transit, 55. Then section 60, we shall go to 63, non-delivery, 62, 64. And eventually we shall do section 70. Now, there are very many other sections, but we're going to pick section per section. So every time you see a video on sale of good, no, it is under a section, because that is how we can best appreciate sale of good. So today, let's dive into section 14 of the Sale of Good Act, and we're going to discuss sale by description. We are going to appreciate the sale by description. We shall go through this. We shall read the act, and then we can attach a case, and then we appreciate the modalities under a sale by description, if you are selling by description. We thank you so much for watching Law School Made Easy. At Law School Made Easy 256, we ask you to subscribe, share, and keep liking our videos. So let's now deep dive into the sale by description under section 14 of the Sale of Good. Let us check it out in the Sale of Good Act, and then we try to appreciate section 14. What does it say? Where there is a contract of sale. By now we know you appreciate a contract of sale. For the sale of goods by description, there is an implied condition that the goods shall correspond with the description. There is an implied condition that when you are in a transaction of a contract of sale and the sale is by description, there is an implied condition, colleagues, that the sale must correspond with the description. The question is, what is an implied condition? Colleagues, when we say it is implied, it can mean literally that it is obvious. That because you told me the type of good you have, you described them, and I accepted your description, it now means that you must deliver exactly what you described. And we shall discuss it length with the judgment of Justice Madrama under the sale of Mebo Bekeyine versus Yuasa. Okay? But now we are saying that there is an implied condition that the goods must correspond with the description. I'll give an example. If you told me you have beans of Nambali, no, these days I'm told there is a type of bean called Masavu. They get fast when you cook them. They get ready very fast. Now, if the Sarah Brenda tells me that they are selling, they have beans. They have beans that are called the Masavu. They are very good beans. They are red whitish in color. And then they describe to the Sarah, I am the Sarah. So, mere description, it means that now when they say there is an implied condition, now me, because you have described the goods to me, I now think it is automatic. You are going to deliver the exact goods that you described, the beans of Masavu. Now, when you deliver to me, when Brenda delivers to me, and now I find out that actually how they described the goods is actually not what they have delivered, then I am at liberty any day, any time to reject those goods. You understand? Let's take a case. It will bring it out well. There is a case of Remo versus Landwa. Remo. This is Remo, R-E, space M-O-O-R-E, then and L-A-N-D-A-U-R. E-R. Now, in this case, they were selling candy fruits, Australian candy fruit. Now, they're supposed to deliver 3,000 Australia candy fruit packed in tins of 30. Packed in tins of 30. So, meaning that the person receiving them was expecting 3,000 candy Australian fruits, but packed in packs of 30, in tins of 30. Now, when they delivered the goods, it was only a half that was packed in 30, and the rest was packed in 24, the tins of 24. So you see, the description is different. You said you are delivering 3,000 candy fruits packed in tins of 30, but now you deliver only a half packed in tins of 30, and then the other is packed in the tin of 24. So the seller rejected them, and court agreed with the buyer rejected them, and court agreed with the buyer that the buyer is at liberty to reject them. Another very important point that you must note, that the buyer can take the ones which correspond with the description and leave these ones. You don't say, why have you taken those ones? I have taken their half simply because they correspond with the description. And I have not taken this because they don't correspond with the description. And the buyer, again, is at liberty to reject all of them. To reject all of them as you have brought them. Okay? So you cannot say, why take this, unless they accept to take the goods. That is one. Now, the other question is, no, let's take another case before the other question. The case of Mebo Bekeine versus Yuasa. This is a very important case. If you are doing sale of good, colleagues, read this case in its entirety. Appreciate the case of the Honorable Mebo Bekeine versus Yuasa. It was a sale by description of a car that she had wanted to use in her constituency, but what was delivered did not match the description, and definitely Mebo Bekeine won the case. But there are many principles I urge you to read, or else I'll get time and I make a video on the case of Mebo Bekeine versus Yuasa, such that we can appreciate the argument of the lawyers, the argument of all the lawyers, the argument of the parties, the argument of court on that case. I promise I'll get time and I do a case of Mebo, because if we're doing sale of good, we must appreciate. Yeah, you can check it out next week on Voices of the Bar. I'll put up that case of Mebo Bekaine on Voices of the Bar, and next week, inshallah, I'll put it up, well discussed, summarized very well, picking out all the principles which are coming up in that case. But now, let me pick the very important bit from that case. In the case of Mebo Bekaine, a very important precedent was set. Judge Madrama said in that case that it does not, that sale by description will actually occur where the buyer has not seen the goods. It is very important that when the buyer has not seen the goods, then you, the seller, you should make sure you bring the exact description. Either the one you have described to the buyer or the one the buyer has described to you is what you must deliver. Okay? But again, that does not rule out the fact that a description may be made when the buyer has actually seen the product but has relied on particular things, described the particular things they want. Okay? So, that is what I want to pick in the case of Mebo Bekaine. It is very important that when the seller describes and the buyer has not seen, then it must match the description. Then, another very important is where the sale is by both sample and description. Of course, we'll discuss sample later. And you were able to deliver the sample and the description is different, it is insufficient. Let me repeat this. Where the sale is by both sample and description, and then the goods the seller delivers, they match the sample but does not match the description, then it is insufficient, it is immaterial. Where goods are by both sale, by sample and description, they must match the sample and it must match the description. So that is sale by description. But I have promised to do the case of Mebo Bekaine versus Yuasa Investments, and next week I will upload it on Voices of the Bar. We thank you so much for watching Law School Made Easy at Law School Made Easy 256. Subscribe, share, and like our videos. Until next time, we shall be discussing sale by sample.